literary critiques may disagree on which is the best contribution of Shakespeare to the English literature, but they pretty much agree on one thing, that one dialogue he uttered is transcendental, which is to be or not to be. I guess that's probably a good way to respond to the question that we have been trying to deliberate for the entire day of evidence before international courts and tribunals, distinct for our similar approaches to be or not to be, which I think is a step in the direction of progress, because from a position of saying no, we are at least in a position of reflection, contemplation, should we or should we not. And without sounding like a skilled cross-examination lawyer, which I doubt if I am, who already knows what is the answer he's expecting from a question. But let me sound optimistic at least, and that optimism arises from some common takeaways which I thought very well emerged from our discussions that we had today during the day. And it is all because of excellent level of participation from the panelists and from the audience. So I think the real credit of this Shakespearean moment of to be or not to be on evidence really goes to all the participants collectively, as a collective thinking exercise. One thing is something on which we all agreed was there are problems. And the problems are at different levels. The problems are across institutions. There are problems within the institutions. But there are problems. Then the question is, if we are looking for similarity at approaches, if the answer is going to be yes, then the question is at which level we are asking that question. If we are going to ask that question at a very higher level in terms of two different institutions, the answer is obviously going to be no, because the institutions are different. If we go slightly lower and try to ask, is this a civil law, common law approach? The answer is probably not going to be the same. But if we try to go further down, dig further down into the principles of evidence as they are applied, dehorse the environments in which they are applied, it seems there is a great deal of similarity. When I was listening to the discussion on burden of proof, evidence, shifting of burden of proof, especially from the European Court of Human Rights, what came to my mind, that is precisely what the ICJ was trying to do in the genocide cases. Maybe when we are looking at it from a higher level, on the top of the mountain, probably we see a bit of clouds and a bit of divergence, but as we try to get closer to it, as we try to get closer to the principles, or just to the notion of the principle itself, we probably can find a lot of similarities. And at least I got that feeling from the discussion that there seems to be a lot of similarity if you're looking at the notion of evidence, the philosophical foundation of a certain principle of evidence. And I'm deliberately avoiding the use of the word rules, because rules has jurisprudentially or normatively a conception of some binding form, but a principle has great amount of flexibility. It is possible, therefore, that one could conceive of such broad pool of principles to which one can go into, draw upon, and use it based on the circumstances and depending on the peculiarities of that particular court or tribunal. It would depend on the level at which it is functioning, whether it's an institution, whether it is ad hoc. But what appears to emerge is presence of such set of principles gives great deal of clarity. We have seen there have been a lot of debate with civil lawyers, common lawyers. We are, of course, going to keep fighting all the time. The question is, do we want to go on crusade for that? If we do go on crusade for that, the ultimate sufferer is the international adjudicative process. And I, to an extent, really like the approach of the last panel, the commercial arbitrators. Somebody made to me a comment, well, they have to make money, so they have to be practical. But whatever it is, they have found a solution. If they have found a solution, if they feel that civil law and common law can coexist, well, we exist in this, the United Nations, in a sense, coexists. We find common grounds and move on. It seems there is a lot of common ground on which we can form a basis on which we can proceed further. Last two quick comments which I want to make is we had a lot of references to historic documentation, 1922, circumstances when PCIJ was made, references to evidence. Was that a situation when the courts and tribunals conceptualized that there would be a satellite imagery which would be brought for their consideration, and they would be asked to say whether they would depend on a satellite imagery? In 1922, did they conceive that they would be posed with 20 cross-examinations or an expert witness and how to handle it and how to tackle it? So the absence of principles of evidence in past, was it a deliberate choice or was it not a necessity then? Today, when the times have changed, with the changing of the times, is it not a necessity? So the slippage or non-existence of principles of evidence was deliberate or purely accidental. The second point is, while finding these similarity in approaches, what we are talking about, we might use different terminologies. Is it really a difference of terminologies? Because what seems to be there underneath, the undercurrent of it, appears to be pretty much similar. I don't want to force my views, but I do think there is certain degree of similarity that one can see if one tries to remove the theoretical trappings, or let's say the definitional trappings, remove the definitional struggle and just try to look at the substance of how those principles are being used and applied. And if we do have such flexible pool, I think it does add certainly to the process of clarity. If at all this project goes through, this was not really originally the idea in the background of this conference, but as I was reflecting and I was speaking to some of the existing or the past judges of different courts and tribunals who are bound to feel is this man is on a mission to tie our hands, just for their comfort, if at all there is such a project which goes through, the project has to have the notion of principles, the understanding of principles, a set of non-binding norms which courts and tribunals can rely upon, use them effectively in their day-to-day adjudication. They're looking at each other because they respect each other. They know each of them has a different expertise. If they are doing it, isn't there a better way to have a more formalized, a more clear, and a more set out set of principles which assists in the overall transaction of adjudication? To conclude, we probably don't want to have a standard of comfortable satisfaction for courts and tribunals which involve a sovereign element. The comfort and satisfaction may be of the institution, may be of the judge, but it is going to start raising question marks in the minds of the users, which are states. And states are sensitive entities. There is an element of sovereignty. How that element of sovereignty functions, how it factors in, has to be taken into account. It has to be balanced out also with how individuals are functioning. We certainly don't want to be in a situation where we have principles of evidence being replaced by ex aequo ad bono, because that creates an equity and a situation of confusion. Clarity will probably help there. But I remember this conversation with a very sophisticated German professor, a very deep-thinking philosophical professor. I would deliberately not name him, and I think it's not written. I wish he had written those words. But I really like those words which he used in a private conversation once. He said, rules of any kind are disabling for a bad judge and enabling for a good judge. And I think if we try to look at that, which is a very deep thought, and principles of evidence can assist in the process, I'm sure it would be a positive contribution towards the overall exercise of how we look at the international legal system and how we want it to progress in the future. But I must say, I'm just joining everybody as to how phenomenal this whole event has been organized. I'm grateful to Judge Kolotkin. It was his idea to have such kind of an event so that we all could speak to each other. And more than that, I was extremely impressed with the manner in which this whole event was organized. We may have disagreed on anything and everything, but there's one common denominator on which we all agree, is this was an exceptionally well-organized event and extremely well executed, for which I take this opportunity to thank Judge Kolotkin, the Institute, and everybody who has been working behind it to make this a success. Thank you very much.